Hello, everyone. Thank you to all of the participants who are joining us today for this panel discussion on the crime of ecocide. My name is Milena Sterio, and I'm the Managing Director at the Public International Law and Policy Group and the Charles R. Emmerich Jr. Calfee, Halter, and Griswold Professor of Law at Cleveland State University's Cleveland Marshall College of Law. I will be moderating today's panel along with Dr. Julie Fraser, Assistant Professor at the Netherlands Institute of Human Rights and the Montaigne Center for Rule of Law and Administration of Justice at Utrecht University in the Netherlands. Today, we will be discussing the recent developments around environmental protection and the creation of a crime of ecocide under international law. As you know, the environment has long been a focus of international law and has become increasingly pressing due to the effect of climate change. The most recent Intergovernmental Panel on Climate Change report this year concluded that increases in greenhouse gas concentration since around 1750 are, quote, unequivocally caused by human activities, end of quote. This human influence has warmed the climate at a rate that is unprecedented in at least the last 2,000 years. The changing climate gives rise to both droughts and floods, more extreme storms and sea level rise, which can all be incompatible with the enjoyment of human rights around the world. As such, earlier this month, the UN Human Rights Council recognized for the first time that having a clean, healthy, and sustainable environment is a human right, and appointed a special rapporteur dedicated to focusing on human rights impacts of climate change. And next week, states party to the Paris Agreement and the UN Framework Convention on Climate Change are meeting in Glasgow to accelerate action towards their climate goals. Recognizing the role that international law, and in this case, international criminal law, plays in transforming our relationship with the natural world, in June 2021, the independent expert panel for the legal definition of ecocide presented their commentary and draft text. Drawing especially from the definitions of genocide and crimes against humanity, the definition of ecocide that was proposed is the following: unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment caused by those acts. This panel will discuss the possibility of adding an international crime of ecocide to the ICC's Rome Statute, which would offer the states parties another opportunity or avenue by which to meet one of the world's most pressing challenges. So it is within this context today that we meet with 3 and possibly 4 experts. One of our panelists might be able to join us in just a few minutes in the field from around the world. So with that, let me turn it over to my co-moderator, Dr. Julie Fraser, who will begin to introduce our panelists.
Thank you very much, Milena, for that. I'm very pleased to start off by introducing Kate McIntosh, who is the inaugural Executive Director of the Promise Institute for Human Rights at UCLA Law School and Deputy Co-Chair of the Ecocide Drafting Panel. Kate has worked in the field of human rights and criminal justice for over 2 decades. And she's been involved in the development of international criminal law from the very early days. And she's been involved in the development of international criminal law from the perspective of judges, prosecution, counsel, etc. Kate has lectured and authored numerous articles and reports on the principles of humanitarian action, international criminal justice, the protection of civilians, and is currently also now working on the protection of the environment from this international criminal perspective. I'm also going to move on to introduce Jojo Mehta, who is also joining us. She is the chair of the Stop Ecocide Foundation and convener of the independent expert panel for the legal definition of ecocide, that has been chaired by Philip Sands, QC, and Dior Falsao. She also co-founded the Stop Ecocide organization in 2017, alongside the legal pioneer, the late Polly Higgins. And it was created to support the establishment of ecocide as a crime specifically under international law before the ICC. Jojo is the key spokesperson and executive director of Stop Ecocide, and she's overseen a huge growth in the movement around this idea. She's contributed greatly to that herself through law conferences, diplomatic events, environmental summits, rallies, podcasts, interviews, newspapers, etc. She is a graduate herself of Oxford and London universities and has a background in communications, entrepreneurship, and on-the-ground environmental campaigning. I'll pass back to you, Milena, for our last panelist.
Thank you. Julie, let me actually take a moment and introduce Dr. Tarini Mehta, who is hopefully going to join us later today. In case she does, she will have been introduced. For our audience members, she will be joining us, if she does, from Asia, and she's having trouble with her internet connection as of right now. Dr. Tarini Mehta is a scholar and advocate specializing in environmental and human rights law. She's director of the Environmental Law and Science Advocacy Forum at O.P. Jindal Global University in India. Dr. Tarini Mehta completed her doctorate in international environmental law from Pace University School of Law. Her research focuses on environmental governance of the Himalayan region. She also holds an LLM in international law from the University of Cambridge, an LLB from the University of Warwick, and a BA from the University of Delhi. She has published widely and been connected with various organizations as a legal consultant, including the UK National Focal Point for the European Union Fundamental Rights Agency, the Indian Council for Enviro-Legal Action, and with the Permanent Observer Mission to the UN of the International Union for the Conservation of Nature in New York. And last, but certainly not least, we have with us my dear friend, Professor Leila Sadat, who currently serves as Special Advisor on Crimes Against Humanity to the International Court Prosecutor. And she's also a Professor of Law at the Washington University School of Law. She has been trained in both the common law and the civil law systems and is an internationally recognized authority and prolific scholar in the field of public international law, international criminal law, human rights, and foreign affairs. Professor Sadat has published over 150 books and articles in leading journals, academic presses, media outlets throughout the world, and regularly lectures and teaches abroad. She's currently visiting at Yale Law School. She's the director of the Crimes Against Humanity Initiative, a groundbreaking project to write the world's first global treaty on crimes against humanity, and the current president of the American branch of the International Law Association, as well as a member of the U.S. Council on Foreign Relations and the American Law Institute. And I could go on and on, Leila, but I'm going to stop here because we won't have any more time. The panel session will be an hour and 15 minutes long. Today's event will be recorded and subsequently posted on the International Law Weekend website. We ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions towards the end of the event. But I do encourage you to start asking your questions as early on. You don't have to wait until the last 10 or 15 minutes in order to ask your question. So with that in mind, let's begin with Jojo Mehta, if you don't mind going first here. If you can please tell us a little bit about some of the details and the background on setting up the Stop Ecocide campaign and also on commissioning the panel of experts.
Absolutely, thank you, and what an honor to be in this company. So we, Polly and I co-founded this campaign in 2017, by which time Polly had already dedicated many years of her life towards this particular initiative of criminalizing ecocide. And although the word was coined back in 1970 and first came onto the international stage at the first UN Environment Conference in 1972 in Stockholm, it was really Polly that brought the concept sort of more into public consciousness and kind of resurrected it, I suppose. Particularly when she discovered that in the drafting of the Rome Statute during the 1990s, there had originally been a clause that would have covered serious environmental crime, but which was dropped before the treaty was finally signed in 1998. And she basically made it her kind of life's mission, and it did sadly turn out to be her life's mission because she's no longer with us, to restore what effectively she saw as a missing crime. We worked together from 2014 onwards. I came from an environmental campaigning background, and we worked closely together. The campaign was ultimately founded in order to fund the diplomatic work, which was already in progress, because our sort of small team was already working with climate vulnerable states such as Vanuatu and other Pacific islands. And at the time, the whole concept of ecocide as an international crime was considered a little bit extreme or left field, or people couldn't quite get their heads around it. And so getting foundation funding was difficult. The kinds of responses that we got was, well, you know, that sounds quite extreme. You know, let's start with sustainable development, and maybe in a few years we can sort of move over to law. And you know, Polly would kind of go, how long do you think we've got? And yeah, so we ended up launching a public campaign because she had quite a worldwide following. And we thought, well, okay, we're going to crowdfund for this work. And that's what we thought we were doing. What we didn't realize, and what's become very evident over time, is that it was actually much more than that. And that it wasn't just about grassroots at one end and, you know, the work happening at the diplomatic end. What we've realized over time, and is very clear from the statistics, or the analytics, I should say, is that where the conversations around ecocide are happening, that's also where the political interest was coming. And of course, in the last couple of years, there was a strong growth in interest coming from a number of different directions. Firstly, from some of these international reports, which have really started to spell out now how stark the situation is, but also from civil mobilizations. So the school strikes, Extinction Rebellion, the Sunrise Movement, lots of very kind of on the ground climate mobilizations that have sort of opened up the media window. And as Polly used to say, I love Extinction Rebellion, they make us look moderate. And so in a way, it's what it's created is the climate crisis as a living room conversation and as a media conversation, which is a space into which this this work could finally kind of land and be heard. And there have of course been working definitions over the years, I mean, including one that Polly created herself and submitted to the International Law Commission in an event in 2010, as I recall, and that was used by the campaign for some years. But there were other groups of lawyers who also did that, did their own versions. And I think that previously it was always a bit in the camp of a lawyer or a particular group of lawyers saying, well, we think this should be a crime and this is what we think it should look like. What was different about this panel was that it actually two key things. One is that it was convened in response to political appetite, and that hadn't been the case before. So we were approached by Swedish parliamentarians, not the Swedish government itself yet, but the Swedish parliamentarians in their capacities as parliamentarians saying, could you, this is obviously your area of expertise, you've been working in this field for a long time, would you be able to convene and sort of commission a definition that we could actually present to our government, that effectively we could credibly say to a government, could you take this to the International Criminal Court for consideration? So that was a new situation, and on the basis of that, and with the help of the deputy co-chairs, so Kate and also Richard Rogers and others, we were able to convene a very diverse and highly talented and renowned group of lawyers from around the world, so that there was a strong, there was a really broad geographical balance of input. There were 12 lawyers from around the world, and also very gender balanced, but also interestingly, balanced in terms of the legal backgrounds. So from international criminal law, like Kate, to environment law, climate law, like Professor Voigt, for example, but also a big range, and of course, public law, international public law, Philippe Sands, obviously renowned for, but also a kind of a range of approaches as well. So on the one hand, we had International Law Commission member and a former ICC judge, and at the other end, we had a quite sort of activist people's lawyer voice from Ecuador in the form of Pablo Fajardo, for example. So very broad range, and I think that was really remarkable, and it also gave the kind of weight of what emerged a strong credibility. And I think it was also interesting, and I'm sure Kate will recall this. I mean, about halfway through the drafting process, I mean, I was sort of, as convener, I was kind of, watching all of these debates happening, and there was definitely a stage at which I was thinking, my God, these guys are never going to agree. We're never going to end up with a consensus definition. But I think it's a huge testament to the willingness to discuss and to the intellectual generosity of that group that actually we did end up with a consensus definition, and one that has been actually remarkably balanced. And I'll just finish by saying that it's been very interesting to watch how it's landed both in the academic and legal communities, but also in the political world and in the sort of wider environmental movement and so on. and the public at large. I mean, I think there's certainly been, and I'm sure this will be addressed by Kate and others, but there's certainly been some, responses in the legal world with the, particular criticisms and questions and all of that. But what's been very interesting from our point of view, and we sit in this sort of interesting position between, the legal developments, the political traction, and the public narrative. And what's been really interesting from our perspective is that in the political world, there's been very little questioning of the definition. And I think, it's the response has been pretty much, oh, right, that's it, is it? Okay. And that's really remarkable. And I think that's, again, a huge testament to what the group achieved, because it somehow has landed as reasonable and logical in the political world. So I think that's really quite a remarkable achievement. Anyway, I'll stop there for now, but obviously very open to questions.
No, Jojo, thank you very much for that introduction. And I wholeheartedly agree that it is remarkable that a definition was agreed by this group of scholars and has, as you say, largely been accepted as, a very plausible definition. Of course, there are always critics, as there always will be to any sort of idea like this. And as legal scholars, we love to do things like critique definitions pedantically. And there, of course, are critiques to this definition as well. So, Kate, I wanted to pose this question to you to perhaps respond to some of those critiques. I'm thinking here about the level of knowledge required around, mens rea, perhaps also the anthropocentric nature of the definition as well. And maybe you could elaborate perhaps on some of the discussions that the panel itself had around these issues. Thank you.
Yeah, thank you, Julie and Milena. Thank you both for organising this panel and inviting me to be part of it. And I just want to say that this kind of dialogue and serious engagement with the issue is exactly what we hope to generate with our work on the drafting panel. And I really welcome close scrutiny of the definition, as well as the opportunity to explain our thinking in more detail about the various different issues. I mean, I had actually thought that one of the more controversial elements, which I might discuss, was our introduction of the proportionality test in the definition. But I'm very happy to talk about mens rea or ecocentrism as well. But perhaps just briefly on the proportionality test then, because that is something that provoked some reactions. So we introduced this test through the requirement that the criminal acts be, if not unlawful, then wanton, which we defined as committed with reckless disregard for damage, which would be excessive in relation to the social and economic benefits anticipated. So I think some initial reactions that I saw were disagreeing with the inclusion of this test and arguing that the crime should outlaw extreme environmental damage, full stop. And that to permit any consideration of economic and social benefit was a concession to, well, the very interests that have got us into this mess, basically. And I wanted to say that I think a number of us, and I think probably on the international criminal law side rather than on the environmental law side, went into our deliberations with a similar outlook. But as we grappled with a central question, which I think was maybe not to harmonise, but to somehow connect international criminal law and international environmental law, it became increasingly clear that we needed to find a mechanism that would allow the kind of balancing that's absolutely central to international environmental law and to environmental law to be imported into the crime of ecocide. And so for the listeners who may not be familiar with that, what do I mean? I just mean that those listeners who are familiar with environmental and international environmental law will know that environmental law has very few clear prohibitions at the international level, right? And is much more about establishing principles and processes for making decisions about exactly that kind of balancing, about balancing environmental protection with social and economic benefit. And of course, those interests are brought together in the principle of sustainable development, which is the bedrock principle of our current international environmental legal system. So it became clear to us that we couldn't develop a parallel legal universe which was unable to speak to this framework or constellation of international environmental law. And the solution we found was to look to the principle of proportionality, which is drawn in this case, of course, from international humanitarian law and more specifically from the existing crime of protecting damage to the environment in international armed conflict, which is in the Rome Statute. And then we use the term wanton, a more familiar term in international criminal law, and in fact, which appears along with unlawful in the crime of unlawful or wanton destruction of property. And maybe just to backpedal 1 second, one of the overarching objectives we had was to use existing law and existing understood terms as far as possible in crafting this crime. And I think that was one of the interesting challenges, was to fit these totally different sort of animals shaped ideas from international environmental law into something that would work in the language of international criminal law. So yeah, I think we're hanging a lot on this term wanton, just to say briefly, and it remains to see whether it can bear all the weight of expectation that we're placing on it. I think one concern, which is the initial concern voice, might be that economic interest might be given undue weight in that balancing, of course, which clearly is a risk. It's not something we felt that the definition could deal with in any more detail than we already had. I mean, it might be possible for more precise instructions to be given, perhaps in elements of the crime which we didn't draft, or perhaps even in an understanding which might accompany the amendment, as with the crime of aggression. But it was at least my hope that we have created with that term a mechanism by which the crime of ecocide could speak to, for example, the Paris Agreement, which is not a very easy conversation to construct, because the Paris Agreement is based on voluntary commitments, and ecocide is obviously an international crime. But it did seem important that these two structures be able to communicate. We couldn't craft an international crime, something of that gravity, which bore absolutely no relation to the whole edifice of international environmental law and agreements. That was nonsense. It would be a complete non-starter. So we're hoping that the word wanton is the sort of portal through which this can happen. And I would say that, at least from my perspective, and I don't know if I speak for the whole panel here, but it's my hope, or at least I think that it may be that the principle of common but differentiated responsibilities, for example, could be taken into account through this portal in considering whether ecocides be committed, which personally I think is very important to have some way of those considerations being included. And I am aware that all of these issues may appear to prevent a lack of specificity and to raise the problem of legality with the definition. In other words, how do you know when you've actually committed this crime if there are so many balancing and trade-offs to be taken into account? And again, it may be possible for more specificity to appear in elements of the crime or in an understanding, or it may just be that that will appear through litigation and jurisprudence. But it did seem to us that just to prohibit severe and either widespread or long-term damage to the environment full stop was unrealistic, and failed to get at what we're really trying to capture with this crime, which is wasteful, grossly wasteful and unnecessary damage that's committed for no socially useful purpose. So yeah, I'm happy to have had the opportunity to express that, and I'm very delighted to respond to any questions about that. Should I carry on talking? I'd really like to go to someone else and come back to me for other potential criticisms of the definition.
Kate, let me, if you don't mind,
Please.
I would like to go to Leila next, and then certainly we will come back to both Jojo and you. Leila, I know you were at Rome when the ICC Rome Statute was negotiated. You were also in Kampala for the ICC review conference. Can you share a little bit with us about your views on potentially adding this crime to the Rome Statute? And I know that there might be some challenges related to this, in particular with the court's jurisdiction. So can you share a little bit with us about that?
I was only 5 years old when I was at Rome, just, yeah, so I've been around a long time. And I should say that, first of all, anything I say should not be attributed to the court. I do represent the Office of the Prosecutor, and I'm speaking solely in my personal capacity. I've been working on ICC issues since 1994, when I was 5 years old. And first, I have to say congratulations, Jojo, to you and the Stop Ecocide movement for really getting the public to focus on ecocide as a phenomenon. Can I just say as a phenomenon, not necessarily a crime, because I hate to be in the skeptic role, but I might end up in the skeptic role only with respect to the ICC, not with respect to your overall goal, which is completely necessary. And so the way and I'm also coming to your conversation a day late and $1 short because I was not part of your discussions, right? So as the director of the Crimes Against Humanity Initiative, we spent 3 years and contacted 250 people. And so by the time we rolled out our treaty, it was people were familiar with it, whereas I learned about this when it was published. So I'm kind of reacting just to a public text. I don't know what happened during the discussions or what the thinking was, and I'm hoping we can explore that. So one of the things about the ICC, so one of the ways I understand this is that environmental degradation and destruction is taking place on such at an accelerated rate that it is difficult to wait for the normal processes of international law to react. So the creation of a new crime is usually done by treaty, right? States would get together, or the United Nations would get together, and you'd have a UN declaration, and the UN would declare ecocide to be a crime under international law. And then you might have a treaty or the International Law Commission. And one of the difficulties of that process is it takes time, and the planet is burning, right? So it is difficult to wait for the normal processes. All the crimes in the ICC statute, however, went through that process. They went through decades of debate and conversation. They were incorporated into national law. They were in UN declarations, and they were mostly codified in treaties, except for crimes against humanity. The other thing, and so what I understand about this is you're trying to kind of jumpstart this by going directly to the ICC and not having to wait for that because of the urgency of the planet situation. The other part that I think I understand is rather than add it to crimes against humanity, which I know some people had proposed, it could be another inhumane act, you could add it, you wanted to actually get at the harm directly to the environment, right? So the environment in a way is the subject of the harm as opposed to the people who suffer from the environmental degradation. And so the decision was not to include it in crimes against humanity, but to make it a separate crime. And I think what's fabulous about it is you have clearly gotten the political community to listen. It's in the Washington Post, it's on NPR, people are talking about ecocide, and now you're having to drag along the international lawyers. And the reason I think it's personally hard to do it this way in the Rome Statute, not impossible, but hard, right, is the Rome Statute requires all Rome Statute crimes to be crimes under customary international law because of the jurisdiction of the court. And not just the nullum crimen principle, which I think is important, right? The legality principle that has to be a crime at the time it's committed, but the jurisdictional mechanism, except for aggression, and even aggression in some cases, says that even if a state isn't a party to the Rome Statute, the Security Council can refer the situation to the ICC. And that means that all the ICC crimes are crimes of universal jurisdiction. They're crimes that no national in the world has the right to commit, because not only, even if their state doesn't join the treaty called the Rome Statute, the Security Council can subject that person, that individual, to the jurisdiction of the ICC. And so really more the question I have, now aggression was treated differently in Kampala. So one of the reasons crimes fell out in 1994, 1995, and 1996 and 1997 is there was so much disagreement about terrorism, about drug trafficking, about environmental crimes, that the new crimes, they just thought, maybe states just didn't have the bandwidth. I was actually taking place during those negotiations. So I think there was a sense the environmental crimes were different. People weren't taking it seriously enough, but there was also this concern that, look, we've just to have something that has mandatory application. It can't be optional. When a state joins the treaty, the state joins the treaty. It's not like the ICJ where then you have to have a whole consent regime. When you're in, you're in. This court has mandatory universal jurisdiction subject to preconditions. And that meant the crimes had to be part of customary international law. Now, aggression, when it came in 2010 in the Kampala negotiations, states complained about that and said, well, we don't agree that aggression is really a universal crime. We don't want our nationals subject to it without our consent. And so with the aggression amendments, they actually had to adopt additional jurisdictional provisions and add those to the Rome Statute, 15 bis and ter. And many people were devastated by that. They were so disappointed by those aggression amendments because they felt aggression should have been treated as the other crimes and not as this sort of stepchild where states could opt in and opt out. And the argument of the other states was, well, we're not in agreement that it's a crime under customary international law that should be subject to universal jurisdiction, et cetera, et cetera. And so the question I kind of have for you is, when you were thinking about ecocide and adding it to the Rome Statute as a new crime, right, adding it to the list in Article 5, and creating this new provision, I think 8ter, I think is what you call it. Did you debate, Article 20 on the ne bis in idem and 21 on the, what do you do about applicable law? Because if you don't think this is already a crime under customary international law, it's going to be really tricky for it to become a Rome Statute crime. And so I guess the question is, maybe, to satisfy the lawyers, not to be critical, but just say, I feel that for this to be effective in the Rome Statute system, it has to be proven to the lawyers, and that could be done with a brief. You have some brilliant people working for you, including people on this call. You'd have to have the brief, the treatise that says this is already a crime under customary international law. And that's why we can introduce it into the Rome Statute at this juncture. There is some evidence that international law permits accelerated formation of custom. Milena knows I don't like the Grosjean moment idea, but the ICJ has said in the North Sea continental shelf that you can have custom created very, very quickly. And certainly Nuremberg is an example of custom being created very, very quickly because there was a global crisis. And so I think if you could connect, and I don't mean this as a criticism, it's just the international lawyer looking at this thinks about, I spend my life with the ICC, right? What about Article 20? What about Article 21? What about Article 22? How do we work around the Security Council referral if this isn't already a customary international law crime? Or how do we deal with state immunities? Because all of the litigation on immunities has been government officials saying, our state's not a party to your statute. We have no obligation to comply under international law. And so I just wonder, I'm sure you must have talked about these things, the expert panel, and how did you sort of finesse a lot of these tricky issues, which is why I think you might be not getting resistance from the politicians, but for the international lawyers like me who have to stand up, help my prosecutors stand up in court against defense counsel who are well armed and better funded than we are, and argue, actually, this is customary international law, and actually we can prosecute. And then one other thing is, what are you going to do about corporate criminal liability? Because the ICC statute excluded legal persons. I wish it hadn't, but it did. And I say this again in my personal capacity, not for the office, but a lot of your defendants, right, are going to be legal or juridical persons, even just looking at your website. And are you going to propose an amendment to the statute that could also add that? That wouldn't have to be under customary international law. It's in our Crimes Against Humanity Treaty, actually, which is the first international codification that calls for that. But I think it's a big issue. So I applaud 2,000% what you're trying to do. I'm an environmental lawyer by heart, but I also have to work at the ICC and think about all the practical issues. And so I'm sure you thought of them during your conversations, and I just welcome the opportunity to discuss it.
Thank you very much, Professor. I'm going to go immediately to Jojo and then Kate for a response to all of that food for thought right there. So please, Jojo, I'd like to give you the floor.
Thank you. Thank you. So first off, I will say that actually Kate's going to be better positioned than me to answer the sort of the legal niceties, in the sense that, in a sense, I guess I'm the storyteller where she's the lawyer. But there are some very specific reasons, obviously, why we aimed for the ICC. I mean, I won't necessarily take them exactly the order that Layla presented, but the fact is, obviously, as she's highlighted and has been mentioned with regard to Nuremberg, there are cases where it is possible to create new customary law, and it does need to probably be in response to a crisis. And I think we'd all be kidding ourselves if we tried to say that what we're in globally is not a crisis. So, effectively that's kind of the bigger bracket for why to still go for that on a legal basis, to still go for that. There are other very key reasons why we aimed for the ICC, which some of which are more symbolic than legal practical reasons. I mean, obviously, there's the legal. There's the fact that the ICC is the only mechanism that kind of directly accesses already existing criminal justice systems because of the complementarity. And so, given that we're not looking at a long space of time to be able to make some serious difference, rather than trying to approach individual nations to legislate nationally, where that could be a piecemeal approach that takes even longer than than the time that it could take to move this forward. It seems more efficient and effective to go for something that, what if you're a member state and you ratify it? I mean, okay, admittedly, it's not everybody joining like at the first instance. It'd be more like crime of aggression, where you decide whether you're going to ratify it, but at least if you do, you have to include it into your domestic legislation. So there's a kind of ability to sort of reach a broader a coherence across borders, which is important. I think the other one is, I mean, and this is quite interesting because, to drop into this legal kind of arena, if you like, is, and it may sound odd, but the time the time before a law is potentially debated, adopted, moved forward legally and moving to prosecutions is actually as important as what happens once the law is in place. Because what we're seeing already, and this is very interesting in regard to some of the conversation that's now evolving in different arenas. So, for example, last week, the International Corporate Governance Network, which is a network of asset management firms around the world. I mean, between them, they manage over half the world's managed assets, like 59 plus trillion. Their official statement to COP26 recommended that governments consider collaborating internationally. In fact, as she said, we recommend you collaborate internationally to criminalize ecocide. Now, when that starts coming from that kind of arena, that there's a level of traction there. And the same thing with, I mean, for example, the Institute of Directors are instructing their members to think about looking at the risk of potentially being prosecuted for ecocide as part of their, 3-year, 5-year plans. Now, and that what that actually starts to kick into motion is a kind of a creativity that only comes when you can see a parameter approaching. And so there's a very kind of obvious practical use in that, in terms of having people start to approach new ways of doing things. And of course, and I would actually take issue in a friendly way with the corporate liability thing, because actually, from our perspective, it's actually the power of it is precisely that it's the individuals. I mean, people in the judiciary in the UK who were, where we have probably the most conversations because we started off here, are well aware, people who've tried to prosecute environmental crimes in the UK, there are some crimes that that could be prosecuted against, a particular individual in that firm, but it's chosen to prosecute the firm because it's easier, and they will simply come out with it, it'll simply result in a fine or something of that kind. If you have a situation where it is personal individual criminal liability, and particularly in the light of the proposed definition as it stands, where it's a crime of endangerment, a bit like directing an attack at a civilian population, effectively you're going to really seriously have people in decision-making positions thinking, is my personal freedom going to be on the line? How do we actually avoid that? And starting to treat that like, I mean, I suppose, I don't know whether how parallel this is legally, but conceptually, like a health and safety regulation. I mean, you don't sit there and discuss, how do we work it out so that someone can nearly break their head open at work, but not quite. most environmental regulation at the moment is approached like that, is how many toxins can we use in this context without crossing a certain regulatory line. But you don't do that with criminal law in the same way that you don't go to a government and say, can I have a permit to kill 500 people for my new infrastructure project? It just doesn't work like that. The taboo is there with damage to people, but it's not yet there with damage to the environment. But we can already see that it's starting to appear because there's a prospect of it becoming an international crime. So that, so there are some very, very practical and narrative and kind of conceptual and insurance and all those kinds of reasons why it becomes important to do that. And then just briefly, if I may, I wanted to just sort of highlight how exciting two particular words in that definition were from the point of view of our campaign and of moving this forward. And one is in regard to what Kate was talking about in terms of the ability of governments to accept and consider this definition, and that's the word unlawful. And I know that when that was all that discussion was happening around that word, I had quite initially a sort of response of, well, hang on a minute, aren't we trying? Isn't the whole point that we're trying to criminalize something that currently isn't criminal? Isn't that what a new crime is, effectively? But what I realized, I had this kind of eureka moment around this word firstly, for the obvious reason that it allows this definition to mesh in with existing law and sort of takes account of the fact that jurisdictions have different already existing provision. But there's another aspect, and that's something that I was really aware of, having come from, originally from on the ground activism, from environmental campaigning, communications around that, and realizing, there are people who've, of course, everywhere, experts, whether that's activists on the ground collecting data, whether that's, researchers, whether that's academic experts, whether that's NGOs, all of those people who are working towards improving environmental regulation are supported by the fact that that word is in there, because everything that they do to move environmental law forward will be supported by this crime, and this crime will as defined here, would become more effective over time because of that. So it has this kind of empowering, sort of drawing forward function, which it wouldn't have if that wasn't there. And I'll give a very brief example. When Extinction Rebellion came on the scene, for example, I heard a lot of activists who'd been working for many years on particular issues and really getting huge amounts done, but not getting much media attention, effectively getting very annoyed with XR and saying, how can you just sort of walk in and sort of somehow you get all the media attention when we've put in all the work? Of course, totally understandable. The real response would have been, thanks guys, now we can actually put forward what we've been trying to do for years. But effectively what that highlighted in the context of this definition was that if you didn't have that in there, you'd be riding roughshod over all of that work. And over, not in all cases, obviously, but, and the same thing with, existing governmental law. So there was something very, it was kind of a eureka moment about that. I think it's really important, actually. And the second one, maybe we'll come back to that later. Otherwise, I'll be too going on forever.
Thank you so much, Jojo. And I really like that you emphasize sort of the longer term view of this project and sort of the way that we're headed towards the future. I'm going to pass then to Kate to perhaps address some of the bigger legal issues that were raised. Kate.
Thanks, Julie. I just want to say, Jojo, I bet the other thing you were going to talk about was the inclusion of the word culture. Am I right? I knew it. I'd love to talk about that as well, but we haven't got much time. So, I'm not sure how much I can respond. I would respond to Layla's brilliant, critique in her own words, really. And I think Jojo's filled in the other part of the puzzle. I guess our position is that we don't see this issue as an insurmountable obstacle for the reasons that you actually highlighted, brilliantly yourself, Layla. It's certainly an important issue to think about. And I also, the customary law status of the crime, which, as you said, would take some creative brief writing to establish for sure. But the situation we're in, the limited precedent of other non-customary crimes making their way into the Rome Statute, the wonderful things that political will can achieve in the right moment, I think would be all the forces that we would be looking towards for support in that area. I do want to say, though, that at least from my perspective, I mean, the panel looked at an amendment to the Rome Statute, and there are many reasons why that makes sense, and there are many reasons why that's a limiting approach. And you've highlighted one important legal reason, but others are, you know, the reach of the Rome Statute, the states that are not parties, the situation of the court, which is, you know, struggling somewhat, et cetera, et cetera. Although I would say that I do think the inclusion of something like a crime of ecocide could do wonders for the credibility and relevance of the court, which I'm a firm supporter of, by the way. I absolutely think that there are other avenues to move this idea of a crime of ecocide forward, absolutely. And I would not suggest that all efforts be focused on an amendment to the International Criminal Court at all. And I think that would be also a way to bring more people along, to have a broader conversation, to address some of the issues that Layla raised. I mean, there is a project in the auspices of the European Union, and the European Law Institute is running a project on the crime of ecocide at European level, which is really interesting. Of course, the one damaged or potential problem of many different initiatives is of this harmonisation of the definition and possible fragmentation. So let's hope that all of these efforts speak to each other. But yeah, I suppose my brief response later would be, we were not hopeless. I think you've articulated yourself the reasons that those obstacles which you highlighted may well be able to be overcome. But let's not focus all our attention on a possible amendment to the ICC. There are much broader conversations to be had about a new international crime of ecocide.
Thank you so much, Kate. Layla, would you
jump in on just one finger? I think that the brilliant thing, like just pulling these two things together, what Jojo emphasizes is really you're trying to change the way people think. And that is, you know, when you have a term like ecocide, it's like the word genocide, right? It's like all of a sudden people are talking about genocide prevention, and, you know, it changes the way people think. And I think in the public space, it's a hugely powerful concept. And we use the criminal law when the civil law fails us, right? When it's the most oppressive form of law we have, we don't use it hopefully as our first choice, we use it as our last choice. And it's because everything else isn't working. And I would also pull on what Kate said, which is I think if you broaden the tent a little bit, you'll get a better, like in the sense of saying the ICC is one avenue. You do have a risk, like we can't prosecute genocide very effectively at the ICC because it's a crime. And once it becomes a crime, and we have theories of strict construction for crimes in our international courts and tribunals, all of a sudden we have this fabulous concept that turns into a very poor weapon for international criminal lawyers. But your goal, I think, Jojo, isn't really, I mean, yes, maybe it's prosecuting people for ecocide, but it's actually stopping it's prevention, right? And so one of the things I would encourage you to focus upon is the ICC. Like, even if you got this in the ICC statute and a handful of states ratified it, I think it would be really hard to use it. And so I think, Kate, your point is that we have to really broaden our approach, because you'll have the raised expectations and changing the conversation, and then all of a sudden people will get disillusioned because in fact it'll be very, so I don't mean to speak, you know, negatively. I totally share your objectives, but I think it's just a little tricky in the ICC without that brief on why is it customary international law, which maybe would be the key thing too, and then getting a state campaign of getting states to implement it. So broadening the tent a little bit and not focusing too much on the ICC, I think would probably be helpful.
Thank you so much, Layla. Let me interrupt this conversation very briefly with the CLE code. So to our audience members who need CLE credit, the CLE code is 561823. It is 561823. And I have also put it in the chat, which is available to all of our audience members. So with that in mind, I would now like to turn to some of the questions that have come in since the beginning of our conversation. So let me read the first question, and I'll invite our panelists to weigh in. And the first question is pretty US centric, but I do think it's an important and very interesting question. And the question is as follows: what steps do you think US courts will have to take in cases concerning the involvement of multinational corporations in overseas human rights crimes to recognize the crime of ecocide? in Kiobel versus Shell is the case of Kiobel versus Shell, a relatively recent Supreme Court case precluding US courts from deciding this type of cases. And so I think perhaps Leila or Kate would be better positioned to comment on this if you have any thoughts on this.
I'll let Kate go for that one if you want to.
I mean, I'm not an expert on the ATS or on US law, to be honest. So Leila, you probably have more to say.
Yeah, so maybe I'll just go to the core point I was making, which is we have the civil law and another question talks about state responsibility. So one of the things that, that I think of when I think of something like this is you want to have criminalization, but you also could have, if you care about prevention, civil liability and principles of state responsibility could be really important too. So, under ATS litigation, you have to show now basically that it's in the United States and a US corporation. I do think, and you'd have to show that it's a principle of customary international law. It comes back to the same problem. You have to show that it's a violation of the law of nations. So you have so many brilliant international lawyers on your team, it would seem that that book or brief should be forthcoming about, and look, in the nuclear weapons advisory opinion, the International Court of Justice advanced a little bit how protection of the environment is so important. We've had it more in the context of armed conflict, where destruction of the natural environment has been called a war crime. And so really you're just bringing it into peacetime as well. And I do crimes against, so that's really, I think you can build on that brief and say it has been recognized by the International Court of Justice in so many ways. Their declarations, building that brief sort of the way they did in the Filartiga case, the very first ATS case. Not the first. Ona Hathaway now tells me there are many, many others that were pre-Filartiga, but it gets most of the publicity, where they made the brief on torture and said, and it was pre-torture convention. So I think it's a great analogy here where you're kind of going to pull it from national constitutions and pieces of national law and the criminalization and war crimes to say this is a crime under customary international law, or a violation of customary international law that can therefore become a crime, which is exactly the process that we used with the Nuremberg Tribunal, is there were treaties and customary international law, and then we said, and that can make it an international crime.
Julie, would you like to ask the next question?
Sure. Sorry, I'm struggling with my unmute button. Thank you very much, Professor, for that. It sort of touches on a point that you raised about the environment already under international law. And I want to go to this last question that Stephanie has just posed to the panel. And she picks up on the issue that there is already within the Rome Statute the ability to pick up on crimes in relation to the environment. I'm thinking here about obviously the war crimes, and Bensouda put out in one of her policy papers earlier that she would look at crimes relating to social, economic, and environmental damage. So the question then really is, do we need to add something like ecocide as a crime when there's already a possibility within the statute? I see fingers going up. Jojo, can I give you the floor?
I don't think we have to look very far to see whether we need more than is already there. I think we just need to see the fact that globally we're barely crawling in a direction we should be sprinting in. And quite clearly that's because there's, everyone's trying to play a game that already exists and play it better. If we don't change the rules of the game, the behavior within that game is not going to change. And so there's a very kind of, basic, obvious need for something that isn't yet there. And I think, that you have this sense with, I know if you're working for human rights or you're working for social justice, at least however well or badly it's enforced, at least that mass murder and torture are criminal, and therefore there's something, there's a kind of very basic support for what you're doing, and that simply isn't the case in the environmental world. And as Leila highlighted, there's a lot of environmental laws in the regulatory sphere, and there's obviously encouraging that, and of course it encouraged that, but clearly it's not enough. And I think that that kind of goes speaks also to something that's actually rather more profound, that goes back, hundreds of years, which is that we have a very deeply embedded mindset where we don't acknowledge how deeply dependent and reliant upon the natural world we are, and how interdependent that we are, and how connected we are. And our law reflects that mindset, and it's done it for many years. And there's no blame there. It's just happened. Effectively, over many years, we've evolved a fairly sort of colonial anthropocentric system that doesn't readily acknowledge what is actually staring us in the face as a rather terrifying reality. So I think that sort of answers that last question rather, certainly for me anyway. But and then the only other thing I would love to come back on slightly is that there's also, I think, in the world of law, there's a bit of a sense that, and Leila said it very clearly, that criminal law is seen as the last resort. Now, you wouldn't say that if somebody was slightly abusing a child. It wouldn't be a last resort. It would be a first resort. It's just a different kind of law. So criminal law is actually protective law. So what protects your right to life is the fact that to kill you is a crime. So, it's a different approach. It's not more extreme. It's just different. And it acts ultimately as protection and, of course, deterrent and so on, and looking at the changing in behavior. But clearly the civil regulations don't actually create that deterrent, but the threat to somebody's personal freedom might well do that.
Can I just come in for a second back on the question, just with maybe a more technical answer to complement what Jojo said, just for the questioner. So it is true that environmental damage can be prosecuted, of course, if it is a means of committing one of the other crimes in the Rome Statute, but that imports all sorts of requirements that narrow very much the scope of environmental damage that could be prosecuted. So, of course, if a genocide was attempted to be committed, or was committed through or including via means of environmental destruction, that would be a way to prosecute that. But as we know, genocide is a very hard crime to prosecute and has this very high requirement of intent to destroy the group. Similarly, the war crime of destroying the environment, with its own problematic proportionality test, does exist, but is of course only applicable in international armed conflict. And we could have a conversation about maybe an easier amendment, which would be to introduce that crime in non-international armed conflict, by the way. And then the crime against humanity, probably the most promising. Leila talked about that at the beginning as an option, which we certainly looked at, not in the panel, because we were quite focused on the new crime, but in another working group, which some of the panel members are in, and it has a bit of a broader remit. So crimes against humanity is the most promising, but a crime against humanity, of course, is a widespread or systematic attack on a civilian population. And while some kinds of environmental harm might be able to fit into that definition, there are clearly acts that we would want to prohibit which cannot be characterized as attacks on the civilian population. So it does exclude a lot of the kind of environmental damage that we're trying to capture with Ecocide, even though there are some options there currently.
Thank you so much, Kate. And actually, I see that another comment/question along the same lines has come in through the chat. And I think, Kate, you already gave part of the answer, but let me just read this question, and then I'll just very briefly invite you or perhaps Leila to weigh in on this one. And this question is as follows. What are the panelists' thoughts on the recent communication to the Office of the Prosecutor on behalf of indigenous Brazilian communities that allege crimes against humanity committed against them in the destruction of the Amazon forest and murder of indigenous people? Could this case be a vehicle for recognizing and detailing the crime of ecocide? If the panel's ecocide definition is adopted as is, how might that apply in this case or change the conversation? So not to, sort of woman's plain what Kate just said, but it seems to me that having a separate crime of ecocide adds to this because of the difficulties of prosecuting this as a crime against humanity, because as you said, many attacks, if we're talking, or many acts rather, of environmental damage and destruction do not necessarily constitute a crime against humanity. So Leila or Kate, yes.
So I won't speak to the issue of ecocide, whether it could be prosecuted under the new crime, because I'll let Kate do that. On the crime, again, speaking personally, not on behalf of the office, I think the opportunity to explore crimes against the environment as part of crimes against humanity is actually important. I wouldn't, I don't think it's a zero-sum game. I think it doesn't really detract from, you're really trying, as I see it, and again, I'm a total outsider. I haven't been involved in any of the conversations. I read about it, over the summer when it was released. So the way I see it is it does go back to the 1970s, your idea, and there was these wonderful articles about whether trees have standing, right, in US courts. We've had this concept where environmental activists for a long time have, even in the US court, said, why do we have to show standing of a person in order to allege environmental harm? The environment is being harmed. And I think, Jojo, if I'm understanding the project conceptually, you really are trying to change the way people think. And of course, it does benefit all humanity if we have a safe, clean environment, which is why now we're getting it from the Human Rights Council and from other bodies. But I do think there is a value added to expanding the idea of crimes against humanity to include an attack against the environment that affects negatively a civilian population. And I think that's what Fatou Bensouda was trying to get at, saying, yes, we have the crime as a war crime. We can have it as a crime against humanity. And I think it is important. We've got that law in the books, and 123 states have already signed on. So there, we just need to write a great brief to convince a pretrial chamber or a trial chamber, which is a little less heavy lifting maybe than the work you're trying to do. And I think that's an avenue worth exploring. So I think that without prejudicing the comment, I don't speak for the office, but I do think that we have started to see a willingness to look at environmental harm as an impact to the human community that's affected by the environmental harm. And I think that would be a very useful mechanism to continue to press on. And I would encourage the new prosecutor to do so.
Just I completely agree with Leila. Actually, I was an advisor on that communication in the Brazilian one. And I mean, Richard Rogers, my co-deputy chair, submitted a communication also alleging crimes against humanity in the context of Cambodia for the palm oil plantation and massive displacement. So there was, in that case, the forced displacement was found as the link. And here it's linking to the attack of the murder of the indigenous people. And I think it's environmental defenders kind of more broadly, the way they phrase that. So these sort of creative framings of the problem and highlighting the impact on local communities are a great idea, and I completely agree that we should do that as much as possible. I feel like all of this is opening a space of conversation. I mean, the talk about the crime of ecocide, the submission of more communications that try to frame environmental damage within the context of existing crimes. It's all going in the right direction. I think they're mutually enforcing to a certain degree. I think this recent Brazil communication got more coverage. I mean, apart from the fact they had a really good press campaign because of the preceding conversation about the new crime of ecocide. And I think for some people reading it, actually, it might not be entirely clear that those were not about the same thing. And I also think that one of the objectives of people filing or submitting these communications to the ICC prosecutor is to highlight, it's a sort of win-win for them. If the prosecutor decides to go forward with it and these crimes are able to be prosecuted within the statute, that's wonderful. If they're not, that's the basis for saying, well, we need a new crime. So I think these are mutually reinforcing. And just to say again, I think as many avenues as possible is really the way to move forward.
And just so our audience knows, right, we charge in the alternative at the ICC. So you can charge something as a war crime, as a crime against humanity, as ecocide, if that was a crime, right? You don't have to pick, oh, I've got the perfect category. So we have more Luddite concern, right? We're practical. We want to win cases at the court. And so it's a little different than what you're doing, which is really trying to change the way people think.
On that topic about changing the way people think, I also wanted to throw to one of the questions that looked at national legal systems and what developments are happening at that level. Of course, there's the ICC, which is always supposed to be a jurisdiction of last resort in any case. But I know there are some very progressive things also happening in national jurisdictions. Leila, you talked about also, giving nature standing and things like this. But Jojo, I actually want to pass to you. Did you want to talk a little bit about some things happening domestically?
Yeah, absolutely. So, I mean, there are now 16, I think, member states of the ICC that have been having conversations nationally in some way. It's different in each place. I mean, some of them it's just a question of, yes, we're following this conversation closely, and when the time is right, you know, we'll be there to support. And that came from Luxembourg to Belgium, for example, which is a real front runner, where they've actually in fact there was meant to be a vote this week, but it's been put off because of too many people absent because of COVID, apparently. But their Foreign Affairs Committee is debating whether to use, in fact, on the basis of the definition that emerged from the panel, sort of combined with a proposal that was also put together last year, is actually looking at proposing that to the Belgian Parliament. But there's a whole range around the world. So the Bangladeshi Environmental and Forest Committee has already recommended to their government that they consider ecocide. The Spanish Foreign Affairs Committee has done the same. And there's another bill going through there's another resolution going through the Environmental Committee in Spain. In Mexico, there's a bill under discussion. In Chile, there's been a group that are working on the new constitution, which is going to be discussed next year, and there's a draft annex on ecocide that's going in there. And you know, even in the UK, which, to be honest, 2 years ago we would have thought would have been, you know, sort of on the moon in terms of the likelihood of them talking about ecocide, has had 3 debates in the House of Lords, the upper chamber in the UK, over the last few months. And the list goes on. I mean, I'm not going to bore you by going through every single one, but there's a lot of interest at the national level, and many have been either basing on or relating to the definition that emerged in June. So that's been very interesting indeed. And just as a sort of flavour of the interest, I mean, before we launched the definition publicly, we held a sort of pre-launch meeting, which we invited around representatives from around 25 states, and we thought we might get 4 or 5. We actually got 13, and quite a few of those have still not yet, you know, publicly said anything. But it just sort of shows the, you know, the level of discussion that is going on. And of course, France, as you probably know, has already legislated for, well, they called it ecocide. Actually, I mean, there's an interesting issue there around legislating nationally, because there's a certain amount of resistance to legislating nationally, almost certainly because of the immediacy of that. And they've ended up doing is using the word ecocide, but effectively describing crimes or offences, you know, it's not as high as a crime, and that were already in place from the 2008 EU directive. And instead, you know, sort of increasing the sanctions, which wasn't really what the Citizens' Climate Assembly in France was after. That said, it has definitely pushed, you know, Macron to be publicly, you know, at least in theory, supporting a crime of ecocide internationally, and that ended up as part of the French climate and resilience law, where there was a particular article saying the government must report back on how they're progressing it internationally. So there's been some interesting kind of interfaces there, and I think France has been kind of almost a pilot case to sort of show that actually for governments, supporting something at the international level is politically cheaper and easier, but serves the same narrative purpose globally, and actually makes a huge difference. So that's been an interesting thing to observe as well. I don't know if that sort of covers enough, but
yes, definitely. We are running out of time. We have about 5 minutes left, but there are 2 other important questions that have come in that I wanted to pose, and then ask our panelists to weigh in, you know, a minute each, basically, so we can end on time. So one question has to do with this issue of state responsibility. And the question is, would it be possible to widen the scope of ecocide to state responsibility, and thus attribute to states this, you know, states could be seen as perpetrators of the crime of ecocide in addition to conferring individual criminal responsibility? So one question has to do with the possibility of attributing responsibility to states. And then there were several questions that have come in about basically environmental damage in the outer space and also out on the sea. So what are the implications for the development of the law of outer space and law of the sea and the crime of ecocide? How would the 2 work together, or could, you know, sort of one be used to push for the development of the other? So I know that's a lot, but you know, sort of 1 minute each, and you don't have to address both. You can just address one of them. Layla, would you like to start?
Maybe on the state responsibility question. So when we think about climate change, and if I understand the crime of ecocide, you're really looking at a specific act that causes specific harm. But they're the more general harms, right? It's the United States failing to cut its carbon emissions. It's states not doing things or doing things in a different kind of way. And so I don't know if ecocide is the right way to get at that, but I wonder, Kate, you had mentioned that you guys are looking at a very broad panoply of kind of measures. I do think that getting states to take international environmental law more seriously is really important. And that's why my thought when I was thinking about putting it in the ICC, well, one of your targets is typically state officials if it's a state act. And then you'll have immunities raised and who is responsible for the, all those kind of technical things. So I do think the state responsibility part of it can be very important. You can also use it to bring cases to the ICJ if you have some jurisdictional hook. So I don't know if that's something you're kicking around, but it would certainly be something I would think of as helpful, a helpful tool in your toolkit.
Jojo or Kate, either state responsibility or law of the sea or the law of outer space. Up to you.
I can come in briefly and just say again that I think the idea of, a treaty, I think a treaty would be excellent. I mean, it would provide obviously for state responsibility, but it would also provide for space to work out all sorts of other things such as implementation measures and so on. So I am absolutely in favor of that work continuing in parallel. As for outer space, I mean, I just mentioned that we did put a definition of environment in our draft. So we said environment means the earth, its biosphere, cryosphere, lithosphere, hydrosphere, and atmosphere, as well as outer space. So our intention was that ecocide could be committed, certainly at sea, including on the high seas and in outer space. That does raise some interesting questions of jurisdiction. But we've certainly wanted to provide for that in the crime. So I think it is possible that we could see some kind of relay race of advancing protections through prosecutions at the International Criminal Court of Ecocide that would try to enter into those areas.
Jojo, you have the last word.
Thanks. And I think that, as I, rather than focusing on a specific area of the law, I think I'd just like to end by saying that, yes, absolutely about changing thinking, but not just about changing thinking, about changing practice, because that's what results from the changing in thinking. And that, people often see criminal law as a stick. We see it as a carrot as well, partly in the way that I described earlier with unlawful, but in the sense, and I say this from my part of my background, which is in entrepreneurship, which is that when you have a clear limit, you also start getting creative. That in fact, it's one of the most brilliant spurs to creativity and innovation is actually having strict parameters. And I like to think of Ecocide as behaving with the kind of corporate imagination, a bit like Ready Steady Cook does with chefs. Which was a program in the UK in the 90s for cookery, where you'd be given a certain set of ingredients and a time limit, and basically said told to create a beautiful dish, and so it's without those limits you wouldn't end up with your unusual and beautiful dish. And I think that somebody asked me the other day, in fact, what would you recommend governments do from a budgetary perspective to support this? And I said, well, they've supported COVID businesses during the COVID pandemic, by giving them grants to tide them over and all that sort of thing. What if they just thought about supporting a few hours a week in every workplace to think about how would you adapt to the fact that you're not allowed to seriously, severely damage the environment? I mean, take it as a starting parameter, but, have a Friday afternoon think tank. I mean, the youth movement calls themselves Fridays for Future. What if we actually used part of our Fridays everywhere, every school, every workplace, every government department? It's only a few hours of our week and we're looking at the end of human civilization. I don't think it's much to ask.
Thank you so much, Jojo, for that ending. I actually lived in the UK in the 1990s and remember that program well. So I do hope that we do all take action also after this debate. As you said, it's not just changing minds, but then also changing our practice as well. Very unfortunately, we have to end. This is all we have time for, but I want to thank very much our panelists for your incredible time, insights, and expertise, and for lending your brains to this really important topic, for being here today with us. I also want to thank the International Law Association for hosting us, and also the ICC and the International Environmental and Energy Law Committees of the ABILA for sponsoring our event too. And I also want to thank all of our participants and everybody who put in a comment or a question for your engagement with this topic as well. Thank you very much for your time and for being here. Thank you, everybody.